Hi, I'm Tracy Sachs, policyholder coverage lawyer at Sachs Dornberger Vita. Very happy to present today SDV's Natural Disaster Recovery Group's Hurricane Series, Part 6. Today's topic is hurricane insurance considerations, contingent business interruption, civil authority, and ingress egress. I have with me today two folks from SDV who work on these topics quite a bit. I'm going to have them introduce themselves. I've got Samantha Oliveira and Ryan Nelson. Samantha, let's start with you.
Hello, everyone. Thank you for joining us. My name is Samantha Oliveira. I'm a coverage attorney at SDV in the East Coast office in Drummoll, Connecticut. I've been with SDV about 5 years now. I represent policyholders in litigation, including extensive discovery, motion practice, and settlement negotiations. I focus my practice on natural disaster recovery for policyholders. Happy to be here today.
Thanks, Sam. Ryan?
Thank you, Tracy. My name is Ryan Nelson, and I'm a coverage attorney at SDV's West Coast office based in Temecula, California. I also represent policyholders in various types of coverage issues, including natural disasters, principally wildfires.
Thank you. So as many of our listeners know, Sachs Dornberger Vita, SDV, as we call ourselves, is a policyholder firm representing policyholders in insurance coverage disputes and coverage issues and litigation nationally. And we've been doing so for, well, actually this coming year will be our 25th anniversary year. So we're very excited about that as well. So let's jump right into the topics. As the title mentions, we're going to talk about ingress, egress. We're going to talk about contingent business interruption and civil authority. Samantha, if you don't mind, we're going to start with you, and let's maybe just talk a little bit about contingent business interruption. Maybe just to start with, what's the difference between business interruption, which is bought as a main part of a commercial property policy, or possibly a builder's risk policy, and contingent business interruption, which may be purchased separately?
Sure. So business interruption coverage, when you think of it initially, you think, what can I get coverage for when my business is disrupted and it can no longer operate as it was operating before and I've lost profits? And that's typical business interruption. And typically that business interruption coverage is triggered when you have a direct physical loss to your property that you conduct business out of. Contingent business interruption covers earnings lost because of damage to facilities that are not owned and operated by your business or controlled by the insured, but properties that the insured depends upon to conduct its own business.
So it sounds like one of the basic tenets of commercial property policies that you have some sort of property damage on the insured premises seems to be obviated by contingent business interruption. Am I understanding that correctly, Sam?
That's right. So you won't have damage to your direct property in order to trigger that contingent business interruption coverage.
All right. So that kind of begs the question: does there have to be property damage somewhere?
Yeah, typically there does have to be property damage somewhere, but like I said, it's not going to be on your property. So, for example, if a hurricane comes and destroys products or a raw material that the insured relies on in order to conduct their business at a facility that's away from your business, and you can no longer produce those materials or produce your product because of that, that would be considered something to look into whether or not it's covered under contingent business interruption.
So it sounds like we're talking about suppliers to the insured's business, and disruptions to that supplier could cause you losses as the insured. Does that mean that every disruption to a supplier to a particular for a particular business is always covered?
No, unfortunately, it doesn't. Typically, under contingent business interruption endorsements or policies, the language does not limit the terms of the coverage to the supplier, or includes language providing coverage for any supplier of any goods or any services, then the courts will interpret this coverage to be very broad. However, a lot of these endorsements include requirements that the damage be done to a dependent property, where you may have to list that dependent property in the endorsement, or that there has to be physical damage in order to trigger the coverage.
So Sam, can you give us an example or maybe something illustrative out of any of the cases that would kind of give us, a better understanding of how this all works? You've mentioned that it requires a dependent property and physical damage, but maybe there's something you could give us that would be an illustration.
The case that comes to mind is a case out of the Eighth Circuit, where an earthquake disabled power to two Taiwanese factories. And the power outage prevented the factories from resuming their manufacturing operation, which included products that were supplied to an insured. And the takeaway from this case is that this was not covered under contingent business interruption, because the power company is where the damage was. The power company would have had to have been the dependent property, and because that's where the damage was. The Taiwanese company that manufactured the goods did not have any damage, and then the insured did not have any damage. And the court ultimately held that there was no contingent business interruption coverage here, because the use or the loss of use of the function of the Taiwanese company or the insured was not direct physical loss or damage to the insured.
Well, that's a great example. So if I understand it correctly, and this is the Pentair case, am I right?
That's correct.
And so Pentair was an American company with facilities here in the US, and they had suppliers over in Taiwan that were producing product for them. And so Pentair had no physical damage.
Right.
And it's also true that even their Taiwanese suppliers didn't have any physical damage. The physical damage was to the power plant that supplied power to the Taiwanese company that in turn supplied product to the Americans. And so the result in that case was what? Was there coverage for Pentair or not?
No contingent business interruption coverage, because there wasn't direct physical loss or damage to Pentair.
Okay, so, and if there had been direct physical loss possibly to the Taiwanese suppliers, do you think the answer would have come out different?
Yeah, I think so. It would be easier for the insured to argue that the Taiwanese company was a dependent property, there was physical damage there, but here there was just too much of a disconnect between the damage and the insured.
So, so that would be typical of most of these type of policies, where your contingent business interruption coverage is somewhat limited. Although it doesn't have to be physical damage at your particular property, it might have to be physical damage at your direct supplier. Is that correct?
That's right.
Okay.
Or at least your dependent property.
Yeah, dependent property is defined as what? Typically a direct supplier?
Yes, or I believe you can list your dependent properties on those endorsements.
Okay, so that's something I would say our takeaway might be that this is something to work very closely with a good commercial broker. Think about your supply chain. Think about the valuations of how much you would lose through such interruption, even if there was no damage at your property. I know of cases that, for instance, a good example here is the tsunami that occurred over in Japan, where it wiped out a lot of people's business. And the power plant there was also, the Fukushima power plant was also affected. And here in the US and Detroit particularly, all these single source suppliers that they were using from Japan, the factories in the US were idle, even though the tsunami happened on the other side of the world. So this is the type of thing, if you're a business that is affected by the supply chain from far away, and if any particular part could shut down your operation, or any particular service could shut down your operation, you may want to talk with a good commercial broker about investigating what it would take and what it would cost to have this type of coverage. You think that's a good idea?
Yes, absolutely.
Let's go on and talk about some other topics. Maybe Ryan, you want to jump in here and talk a little bit about civil authority. So, we just talked about the contingent business interruption. What is civil authority coverage, and why would we need it?
Thank you, Tracy. So civil authority coverage is another example of business interruption coverage. The main trigger for that business interruption is some type of government authority, whether it's a governor, the president, even fire department, local police department, issuing some type of order that restricts access to the insured's business, whether that's a retail business or some type of manufacturing, something like that. Similar to the contingent business interruption, is there has to be some type of physical damage associated with that civil authority order that restricts the access.
So, okay, so I think we're kind of hitting on a common theme of maybe the topics we're talking about today. And often I do what I would call insurance coverage geography and sort of say, where in the world of insurance are we? And so we're talking now about that part of the universe that essentially is first party coverage. And it's particularly not just first party coverage, but it's property first party coverage. And I mentioned at the outset, it's about potentially commercial property policies, maybe builder's risk policies are two good examples of that. But the interesting part is that one of the things that you might have seen in those who are watching this whole series, that in some of the previous episodes, we've talked about the idea that in order to tap that type of coverage, you need property damage at the insured's location. And so it sounds like certainly what Samantha just pointed out was when it comes to the this contingent business interruption, no, this is actually brought specifically when the property damage happens elsewhere. And now, Ryan, it sounds like with civil authority coverage, it's a similar situation where even though your property may not be physically injured, there could be coverage. Am I understanding that correctly?
Yes, that's right. So this is just another example where property damage is needed, but the property damage doesn't need to be at the insured's location. So for example, there's a hurricane or a tornado, some sort of peril that is covered by the insurance policy. That destroys a building down the road, and in response to that, police, firefighters, they have to cordon off the area. There's no longer access to your business. Your business doesn't sustain any damage. It's okay. You could go there if you could get access, or your customers, if they could get access, could be there. But for that damage, the civil authority, the police, the fire, they wouldn't be there. They wouldn't be shutting down the area and preventing people access to your business. So that would trigger that coverage.
Well, let's talk about that for a second. When we talk about access, I mean, it's not as though suddenly whatever happened, civil authority caused your place to be in a bubble that no one can get in or out. If they shut down, let's say, a bridge that gets to you, but you could get there by boat or by helicopter or some other way, how does that play into the coverage determination?
So there are issues with the degree of restriction. This applies in both civil authority and Ingress, Egress, which we'll touch on later. It has to be a reasonable means to get there. So just because there is an available means, such as, oh, well, you could park and hike around a mountain and make your way there, or find some other way to get there. It has to be the reasonable means, the usual course of business of how customers or employees generally make their way to your business.
All right, so that could, go ahead, Samantha. You want to add a comment there?
Yeah, I know we're talking about hurricanes, but on the topic of natural disasters and civil authority, we've been seeing a lot of these civil authority claims coming through related to COVID, where the government shuts down, whether it's a stay-at-home order or a quarantine order or a limitation on how many folks can be in a restaurant or a bar. Those the civil authority coverage considerations can be considered there as well.
Well, that's a good point, and maybe it helps, even though we're here as part of a hurricane series, it does illustrate maybe one of the other issues when it comes to civil authority, and that we're still talking about not that there is no physical damage, but it doesn't have to be physical damage at the insured premises. So the open question, and we those of you who want to go on our website, we have an entire series about COVID coverage too, and you'll see that there's a recurrent theme that Samantha is pointing to here, and that is that there does still have to be physical damage somewhere. and somehow, and that's still the open debate. The case law is coming in fast and furious on different issues. And in fact, our office tracks that. And you can find that also on our website, the current status of cases. And Sam, you're part of that COVID task force that's been putting out the weekly newsletter. Am I right?
That's right.
Yeah. So it does illustrate the issue that although you might not need property damage at your particular site, you do need property damage somewhere. And as to the COVID issue, the question is it property damage or not when there is a contaminant on physically present? But going back to this idea, so the question is, for civil authority coverage, maybe getting closer to the hurricane situation, we also had a lot of experience, and one time comes particularly to mind, which is Superstorm Sandy, when Manhattan was essentially shut down and there were orders not to go below 30th Street, and the bridges might have been closed or ordered to be closed. One of the side notes, maybe not a real critical issue, but I think that might have been the first time that there was potentially determinations that the mayor's tweets were in fact a order for purposes of civil authority orders when he's ordering your employees not to come in. And here it is, your operation is fully functional, except your employees can't get there. So probably an interesting fight about civil authority coverage there. And there, of course, there is physical damage somewhere. So Ryan, back to you on this stuff. What do we say are the biggest issues, if we haven't covered them all already, that policyholders encounter when seeking this type of civil authority coverage?
So a lot of it is going to depend on the specific language of your policy. But with COVID and with contingent business interruption, a lot of this is always going to come down to, is there physical damage caused by a covered peril that the civil authority is responding to? So if you take the COVID example, you have stay-at-home orders, or certain businesses are shut down. People are restricted by a government order from going there. And so then the question becomes, well, is this order related to some physical damage somewhere?
And as you mentioned, a covered peril. Now, interesting, for the hurricane purposes, we have a lot less issues. It's going to be clear what the physical damage is, and hurricanes are generally covered. I've yet to see a policy that actually excludes hurricanes. It may have deductibles or sublimits, but it's going to be covered. So,
right.
Is this a coverage that I mean, we're not in the business of selling insurance, and we're not brokers. We do have a lot of broker partners, but again, I think the same recommendation comes here. In advance, well in advance of any particular damage, you should be sitting down with your broker and thinking about what are the ramifications if something were to happen where your access is denied. Do you think there are particular types of businesses that are more prone to having be at risk for this type of situation?
I think businesses in areas where potentially they could be cut off if they only have, there's limited access in and out. That tends to play more into ingress, egress coverage, but I think applies equally to civil authority. The thing with civil authority is, even if there is access to your business, the roads are fine, there's no damage there, but let's say a hurricane damages some chemical plant, and then there's damage there, and out of abundance of caution, the authorities prevent access to an entire area of a town. Even if you could get there, you're not allowed to go there because of gases or fumes or threat of fire spreading or something like that. So they're preventing it. That could be an issue too. So you really have to look at historically, what kind of natural disasters have come in, what kind of issues have other businesses dealt with in the area. Factors like that really play into it.
All right, so maybe let's open this up a little bit, and we'll talk to both of you about ingress, egress coverage. What is ingress, egress coverage, and is it really different, necessary? What does it cover that maybe the other things don't already cover?
I think it is different and it is necessary. So ingress egress coverage is coverage to pay for lost business or revenue triggered by physical damage that's caused by a covered peril that prevents or hinders ingress coming to a property or egress leaving a business. It's different from civil authority coverage because it doesn't require an order of civil authority in order to be triggered. So, for example, if there's a hurricane and on your property there's a ton of trees down and no one can get to your business, that would be an example of an ingress loss to your business that may be covered under ingress egress coverage.
All right. So a little bit of difference there, that essentially it does sound like, unlike civil authority, which of course requires some sort of civil authority to make some sort of order, but doesn't necessarily require some sort of physical inability to get to your property. It's the civil authority that's keeping people from getting to your property. And maybe unlike the contingent business interruption, where the damage is happening somewhere far away to maybe a direct supplier of yours, here there is there's something physical happening, and it's happening to your specific ingress egress. Do you think that's a fair summary?
Yeah, absolutely.
So Ryan, did anything you wanted to add or comment about the ingress egress coverage here?
Yeah, so I think there's some overlap with these types of coverages, but there's also a lot that they don't cover. Ingress egress generally has some type of a radius from your business, whether that's 1 mile or 5 miles, and it only applies to access to your business being physically prevented, whether that's, like Samantha said, trees that got knocked down, or there's flooding that prevents people from driving on the roads to get there. Whereas civil authority, there could be a civil order that goes along with that type of damage. So there's flooding, or there's some type of damage, and then the authorities are putting out an order preventing people from going to that area. So that's kind of where there's overlap. But civil authority could restrict access or people getting to and from your business without the ingress egress routes being affected at all. So if there's a building that's damaged and emergency personnel need to work around there, so they're prohibiting access, the road is still passable, but because of what the authorities are doing, no one can get to your business. On the other hand, if there's a flood and the road is flooded, but there's no civil authority order telling people to stay off the roads, but they're just physically impassable, then that's where you get your ingress egress coverage.
Yeah, it's interesting. I just want to highlight the idea that the unique feature is that there's a geographic limitation, it seems like, for the ingress egress that doesn't necessarily apply for certainly not for contingent business interruption. Our examples were things that were happening around the other side of the world. And it doesn't seem that way. If the civil authority says that they can't come to your site, it doesn't matter where the physical damage was. It doesn't have to be within 1 mile or 5 miles, but that's an interesting point. And so I think you're saying that different policies might have different geographic restrictions in them of varying length or size, I would guess.
Correct. Some of them have different mileage, whether it's 1 or 5. I have seen civil authority provisions that limit it to damage to adjacent premises, and so then you're going to get into a whole argument of what is an adjacent property and whether or not those terms are defined to determine how far away the civil authority, the property damage needs to be that the civil authority is responding to.
Another important consideration when looking at your ingress egress coverage or determining whether or not you need it is how many access points there are to your property, how many ways, or to your business, how many ways can you get in and out. There have been cases where one road was blocked by trees and one way to get to the business, and the other road wasn't blocked by trees, and the court has to determine whether or not there are reasonable means to get to the property. And in some cases, if there are more than one way, one road is blocked and one road is not. Even if your business does suffer losses and less folks come, there still may not be coverage under there because there's still a reasonable means to get to your property or to your business.
Yeah, it's interesting. So it makes me think about the idea that, you know, the examples I gave earlier about Manhattan, and it was the workers who needed to get in. If you're a manufacturer of something, it might be your product, and maybe your product comes in by train, maybe it comes in by truck. And although people can drive in, or they can walk in, or they can do whatever, you still may not be, there still may be ingress egress problems because you can't get in the type of vehicle that brings in your supplies. So that's an interesting point, Samantha. Having said all that, it seems to me that, you know, kind of just big picture, we do insurance coverage of every type and stripe for all sorts of policyholders. We do the liability stuff, including general liability and other liability policies. And this, as I mentioned, is in the first party realm of property damage. And it always struck me that there is so much more case law and so much more examples out there for general liability, and less though for commercial property and builder's risk, but still quite a few. And even within that, there are you know, a smaller but still sizable number of business interruption cases for direct property damage cases, particularly in the builder's risk context and commercial property context. But as to this, which is with the contingent business interruption and the civil authority and the ingress egress, are any of these common enough that you see a lot of case law? Which one is the most frequent and least frequent here? And how rare is the cases that arise under this that end up in a printed decision? So I don't know, Ryan, let's start with you. As to ingress egress, it seems like that might be one of the ones that's kind of rare.
Ingress egress is very rare. When I was researching different cases for this, there is a case that stands out, and it's from the Eastern District of North Carolina from the year 2000. But besides that, there were less than 24 published cases that I could locate on this topic, which could suggest that this is something that isn't necessarily litigated too often.
So that's the Fountain Bower Board case you're talking about?
Yes, and that case addressed two issues of both whether or not physical damage needed to be present at the insured's location and what the level of access was. And so the court held that no, the insured's property, which was undamaged, they manufactured boats there. And so the factory could open, it could operate, but the roads were flooded. They couldn't get there. The owner of the factory ended up renting these large trucks, and he picked up all his workers, and he was able to drive through the flooded roads. And so he was actually able to get his workers there, but they wanted the reimbursement for the trucks and any of the interruption prior to that. And the court found that renting trucks and getting your personnel, your workers on there was not a reasonable means, so that there was actual interruption. So the insurance company argued that since you were able to get there, there's no coverage. Instead of, and we didn't want to pay the cost, the extraordinary cost that it took to actually get people on site. Court disagreed, gave them the extra cost, and said, just because you had access doesn't mean that there's no coverage if it wasn't ordinary access, and this was not. Right, yeah, you still have to have a reasonable means of access, and the owner of that company took extraordinary means to get there. All right, this has been a great discussion, and I don't know if there's anybody else wants to jump in and say anything else before we close it out. Any other thoughts or comments here? If not, what I was going to suggest is that it seems like maybe a common theme for takeaway and recommendation here is if you're in a situation where you either have a limited number of suppliers for essential things that you're producing, you have limited access to your property, either of those should be a trigger for you to sit down with a good commercial broker and talk about whether it's worth you paying for contingent business interruption coverage or getting ingress egress or civil authority coverage under these circumstances. It's a funny thing about insurance. You always realize that you definitely needed it after the disaster, and it's harder to figure out in advance. And that's why we partner with so many good commercial brokers who help
our clients with such issues. But if you have any doubts about any of these things, please feel free to reach out to Ryan, Samantha, or myself. And thank you. We enjoyed doing this presentation with you.
Thank you, everyone.
Thank you.